Well, good afternoon. My name is Mickey Brock. I'm the treasurer of Houston LERA. I want to welcome you to the second quarter program for Houston LERA. And the topic today is labor law developments in the Trump administration. I'd like to offer some special thanks to Emily Smith. I don't know, is Bernadette joining you, Emily?
She'll be joining us later.
Okay. Well, Emily and Bernadette are with National LERA, and they have been great resources for us. And also they'll be doing the Zoom technical work. So we appreciate their participation in this. A couple of housekeeping items. If you put your questions into chat, we'll try to get to those. We're going to record this meeting, and it'll be available to those people that are members of Houston LERA. So it's a members only access to that. We have gotten approval for 1.25 hours of Texas attorney MCLE credits, and also for 1.25 hours of SHRM recertification credits. We've got a distinguished panel today, although we're looking for one of our presenters.
Not here.
But we'll work through it.
She's on the open lookout for him.
Okay, good.
She might have been sitting next door too.
So our first presenter is Lance Bowling, and Lance is a management attorney with Littler. He's spent about 30 years in various management-oriented labor relations roles. And Walter Darr is a field operations manager for FMCS for now, and has over 34 years of labor relations experience and mediation experience. And hopefully Amar Kwacha will be here. He is the legal counsel for Teamsters Local 988 and spent over 18 years fighting for people's rights through his support of unions and other organizations. So we've got a great panel today, and I want to thank the speakers for taking the time out of their schedules to make this presentation today. And I guess there was one other thing that I wanted to talk about. On the Texas attorney credits, the way that's going to work is you will put your name and your Texas bar number in chat. And then later in the program, we will put in the course number that you can use to get the credits. For SHRM, what you need to do is put in we're picking up a lot of background noise. Sorry about that. I guess you have to be quiet. For SHRM, if you'll put your name, put SHRM in there, and let's see. I guess the sound is not good. Can you hear me better now? Or is it the background noise that's the problem?
Yeah, I think it was, folks opening their sandwiches and stuff, Mickey. It'll probably calm down now.
Okay. All right. For SHRM, put in SHRM recertification credit, your name, your email address, and your telephone number in chat, and then we'll take care of that and get something to you on that. With that, I'm going to turn it over to Lance. And Lance, if you would take over, please.
Yeah, sure. As you noted, Mickey, Omar has not arrived, and so as we go through this, we'll do our level best to give some insight on the union side to the extent that we have that kind of working knowledge. So that may be a little bit of a hole here, but we'll do our best. And I just want to start with, we are talking about the first 100 days, involving labor law, involving the National Labor Relations Act. But this really is not just limited to the National Labor Relations Act. The National Mediation Board has seen significant cuts in the number of employees they have. The Department of Labor has seen a number of cuts in the number of employees that are working for them. And Walter, of course, can speak to this, but just because My dad was a federal mediator for 20 years. They've been in the crosshairs of reductions as well. And Walter, if you could kind of start us off with, what that's looking like for you and your colleagues at FMCS, and perhaps some of your colleagues in some of the state mediation agencies and what they expect coming down the pike as a result of this.
Yeah, thanks, Lance. I appreciate it. Mickey mentioned that I'm with the FMCS currently, or maybe, or still, or we're really in a state of limbo at this point. So there was an executive order issued by the administration in March that basically directed several agencies, the FMCS being one of those, to reduce themselves to the size that would be necessary to perform only their statutorily obligated work. And so at the FMCS, we had, I think, 14 different pieces of 14 different authorizations that let us do the work we do. And it ranged from public sector mediation, school districts and schools, to governmental mediations, to federal employment mediations. We were called upon to mediate for federal employees and unions before they went before the Federal Services Impasse Panel. And so we, at our peak over the last 2 years, we're at about 200 employees, probably 120 of those being mediators or commissioners, as we refer to them. As a result of that executive order, we scrunched down to, I think the current staff is about 11 in the agency, all based out of DC, and 4 of those are mediators. And at last reading that I got, I'm currently out on administrative leave awaiting a RIF to take place. But on the last reading that I got, they were interpreting their statutorily required work to be Taft-Hartley injunction work. And for those who aren't familiar with that, it's where there is a work stoppage that's large enough that the president intervenes and then calls for a mediation period to occur. The last Taft-Hartley injunction mediation that occurred, I believe, if my records are accurate, was about 2002. So to put it in perspective, the ones that are probably at the forefront of all of our minds, the big ones that have happened recently are Boeing. There was no presidential intervention in that, and that lasted quite a while. And then the short ILA strike, right, that happened. There also was no presidential intervention in that. And he did not invoke neither President Biden in one case nor President Trump in the other case invoked their presidential rights under the Taft-Hartley Act and sought injunctive relief to require the parties to go to mediation. And so if not then, when, right? Because those were certainly had a very large economic impact at a regional level, and some could offer even at a national level when you talked about the ILA and the closing of the ports, effective closing of the ports. Where it stands for the FMCS right now, we have been, my words, not anybody else's, we've been singled out along with a few other agencies for additional reduction. And so because of that, several state attorneys general band together and sought to get injunctive relief to have the court step in and say that the executive branch of government, specifically the presidential administration, didn't have the authority to reduce the size of an agency. And they found a court in Rhode Island that agreed with them. And so in the lawsuit that was led by the Rhode Island Attorney General, they got the court in Rhode Island to say the president does not have those abilities. And so we were notified last week that we indeed would not be leaving the employment of the government on this last Saturday as we thought we would, and that we were still on administrative leave while the case worked its way through the courts. In the order coming out of the Rhode Island court, which was dated the 13th, the judge gave the parties, or gave the defendants 7 days. It was ourselves, it was the FMCS, 2 other agencies, And then also some individuals were sued in their official capacities with the government. And so he gave each agency 7 days to reply with a plan on how they intended to comply with his order. And that if they could not comply with his order, then he asked for a reasoned explanation as to why they couldn't. The interesting thing in the discussions we've had about that ruling is that rather than leaving it implicit, which one might suspect that the court would have, the court took the explicit position and said that while the executive branch at the presidential level doesn't have the authority to reduce the size of agencies, the agencies themselves can and are completely vested with that authority. And that if the agency intended to do that, then and could still meet their statutorily obligated work, then they needed to present a plan to the court to allow the judge to determine whether or not they were in compliance with the order. Would not be surprised. So that those plans will get filed this next week. They have until the 20th. Would not be surprised to see this pushed up through the appellate court. I believe the appellate court in that district will uphold the judge's decision, and then wouldn't be surprised to see it pushed to the Supreme Court, and then we'll just see where it goes. So for those keeping score, it's FMCS. It's also the Minority Business Development Agency and the Institute of Museum and Library Services. Those are the three that the state attorneys general filed suit over. There are also some other suits out there that have been filed. One by the AFL-CIO, and I believe the judge in that case asked for a show cause as to why an injunctive relief would be necessary based on what's going on in Rhode Island. And so it seems like maybe they don't want to double up on the injunctive relief, and so that's going through the process. So long story short, we've got probably I think we had about 90 mediators in our agency left after folks took the voluntary deferred resignation that the Trump administration offered government-wide. And out of those 90 mediators, we have about 86 mediators and managers like myself. We have about between 80 and 90 that are currently on administrative leave, waiting to see what the courts are going to do.
Okay.
And have 4 in DC who are, I guess, actively working cases. I don't know what they're working on because there's not any Taft-Hartley stuff going on. We do have some limited circumstances where parties have to pass through FMCS mediation before they can go to self-help, and they were going to continue to work those cases. So I know that's a lot. I'll kind of take a breath there. And Lance, if you want to add anything to that, happy to have you.
I guess a couple things, Walter. First off, let's say you're a Texas employer. Texas doesn't have a mediation arm in their state government, and you're in negotiations with the union, and you're at or near impasse. You need help to get things over the hump, so to speak. Where do you go?
Yeah, so in states like Texas, well, and let me expand it beyond that, because there are several states that have state mediation agencies who have never staffed those agencies. Because in almost all of those municipal agreements, those municipal contracts, public sector contracts, should I say, which is broader, it gave the parties a choice. They could go to a state entity and receive mediation services, or they could opt to bypass that entity and go elsewhere. And what we found is the vast majority of them went to the FMCS. And it was for a myriad of reasons. The largest being, they would report to us that the state mediation agency just wasn't staffed, and would sometimes also report to us that the quote unquote quality of the mediation that they could receive was very different because the individuals were kind of limited in scope to what they were exposed to, where FMCS mediators were exposed to a much broader scope of municipal sector agreements. There are some private sector companies out there cropping up. most of them made up of current/former FMCS mediators. It's kind of weird to even talk about when you're still in the employ of the federal government. You know, my intent's not to use this time to endorse our piece, but I'm involved in one as well, and we're working hard to just provide services. What we're hearing from parties is that they are attempting to contact the FMCS and they're leaving voicemails and they're not getting any calls back. And I think it's simply a volume issue, that they're not able to respond to the incoming calls when they only have 4 mediators. And the support staffs have been put on administrative leave as well. So yeah, it's an interesting conundrum, Lance, and it's gonna, you know, hopefully the next 7 days will give us some hope and some guidance when the agencies themselves come out with their plans. We'll see.
You know, one other thing that comes to mind for anybody who's you know, a practicing advocate in labor arbitration is, you know, many of us have gotten away from using American Arbitration Association because they're expensive. We're trying to save money, and we've paid our taxes. FMCS has provided panels to private employers for years. Is that service still available?
So, sorry. So the short answer is yes, it is still available. The longer and more pertinent answer is, because of the reduction in staff, there's not currently a way to either add someone to the FMCS panel, or from time to time, individuals were removed from that panel, right? The FMCS would get feedback that a particular arbitrator was maybe not issuing their rulings in a timely manner, or had a backlog, or or some procedural issue during the arbitration. And the FMCS had a process where the arbitration review panel could undertake that, and then someone from the panel would reach out to that individual arbitrator and just see what was going on, right? See if it was something that they just weren't talking to the parties about. None of that exists at this point within the FMCS. So that's all the factual side. My personal belief is that the rostering system there itself is at great risk. There's no one left in the IT department at the FMCS. It's now being supported through a central governmental agency, and while it was produced by a third-party vendor, there was internal knowledge of the system that helped keep it up and running. So the other thing with that system is it's only automated if you want a panel of 7. If you want any number other than 7, it required human intervention. And there's only one person there in what used to be about a 6-person shop to do that. And so I don't think they're responding. They may be responding to panels that are separate from the 7 request, but I'm not entirely sure. I'm not aware of another entity at this point that's taken that on. I know the entity that I'm involved with is in the process of developing our own FMCS rostering system that would run very similarly to the way the FMCS system ran, with the exception that we're developing a system that's not going to require the human intervention. It'll allow parties to request panel sizes of varying numbers, and it'll give them those panels based on the criteria that they can select within the system. And for those who aren't familiar, there's very simple criteria like, are you willing to do Zoom? You're not willing to do Zoom. Where are you geographically located? Where are your areas of expertise? And so parties are able to select a panel and narrow it down where they can perhaps more successfully, through a strike process, end up with an arbitrator from that panel that fits their needs. So yeah, another area within the agency that I think is at great risk.
And just to tease that out a little bit more, I know that there's been, you know, in recent years, a far more robust process and set of requirements for you to become a member of the FMCS panel. Is that part still being administered?
It's my understanding, while I'm not speaking on behalf of the FMCS, It's my understanding that process is not going on now, that there's no way to add arbitrators to that roster. And also the Becoming a Labor Arbitrator course is no longer being offered by the FMCS.
Okay.
Lance is Mickey. Omer is on the Zoom. So,
Yeah. Okay.
you can loop him in. And Emily, is there any
I'm
way that
here.
you can spotlight, Lance, Amir,
His head has a halo.
and, us? And Omer is Zoom user, I believe.
He's here with us now, Mickey.
Oh, okay.
I was downstairs, how we doing, bud?
Good to see you.
Need the meeting.
Okay.
Sorry about that delay. Welcome, Omer. Appreciate you being here.
Here I am. Happy to be here.
So with that, Mickey, we do have a lengthy deck, 42 slides in. There's a lot of legalese, gobbledygook type stuff in there that I'm sure would put some of y'all to sleep. But important to cover some of these issues that we've included in this deck. And, I would say throughout this process, if anybody has a question that's actually, if you're live or if you're on Zoom, don't hesitate to unmute and just say, I've got a question about that, because we want this to be as interactive as possible. But the first thing I wanted to cover about the first 100 days is, what has happened at the board when it comes to its leadership. Now we know Jennifer Abruzzo was let go about 5 days into President Trump's term, which is kind of consistent with what President Biden did 4 years ago with respect to the Republican General Counsel that was in office. And there hasn't been a whole lot of squawking about that. I think that issue has kind of been resolved by the courts previously. But when it comes to the board itself, when Wilcox was let go from the labor board by President Trump, and she filed a lawsuit in DC District Court, and I believe won a preliminary injunction to be restored to work, and then it went up on appeal and she was back at work, but then it got to the Supreme Court, and the Supreme Court said, you can keep her out until this is decided on the merits. So as it stands right now, Wilcox is not a member of the board. She is not involved in the board's processes. And, kind of what we've seen before, for instance, in, the Noel Canning period 15 years ago, when, a lack of quorum at the NLRB did not stop the NLRB from issuing decisions, and all those decisions had to be revoked when the Supreme Court ruled that they were invalid. We're in a no quorum situation, and so the labor board is significantly limited in what they can do. And when I say the labor board, I'm talking about the actual members of the board, the five people who head the National Labor Relations Board and kind of serve as the kind of Supreme Court of the labor board, for lack of a better way of kind of looking at it. And so the things that they can't do right now include deciding cases that are up on exceptions, which is the term used for appeals before the board. So if you have an ALJ decision that you disagree with after an unfair labor practice trial, you would file exceptions with the board. Well, the board can't even decide those cases anymore, not until they have a quorum. They also are unable to issue regulations. And in somewhat of a strange wrinkle, they are unable to seek 10J injunctions. A 10J injunction is a discretionary injunction by the board that allows them to go to district court to enjoin the employer or mandate that the employer, subject to the unfair labor practice, do something. For example, if, you know, the organizing committee of a union that's, you know, being organized, all of them are let go, that would be something that the labor board would want to go and seek a 10J injunction to put those people back to work pending the resolution of the unfair labor practices. They're not allowed to do that right now, but interestingly, there's another section of the act called 10L, which mandates that the board, if certain unfair labor practices are alleged, mandates that the board go to district court and seek an injunction. So, for example, many years ago, I was counsel for Kaiser Aluminum, and we had a strike in Gramercy, Louisiana, and we had a reserve gate. And the union started to picket the reserve gate, and we went to the labor board in New Orleans, and we filed an unfair labor practice and demanded that they go seek a 10L injunction. That's the kind of situation where the board doesn't have any discretion. They have to go do it. So they're allowed to continue to do that. That's statutorily required. They also aren't allowed to review elections at this point in time. So if there's some legal issue that arises in an election, they cannot decide that issue. But they do, the board is not, you know, non-existent at this point. The act is still alive and well. You know, the regular business of the labor board and its regions continues. So, you know, petitions to represent employees, decertification petitions as well are being processed. Unfair labor practice investigations and trials are going forward. So it's kind of like when you really get to the top of the food chain, so to speak, at the board, that's where you run into issues where they lack authority at this point in time. Omar, did you want to add anything on Wilcox's discharge or the lack of quorum issue?
I guess, and if folks can hear me, I'm Omar Khwaja. I'm legal counsel for Teamsters Local 988. It's a labor union out here affiliated with the Teamsters. And yes, I guess from my perspective, I do understand, well, it's not just my perspective, but I think that the firing of the General Counsel and the firing of Ms. Wilcox are kind of separate and distinct to the extent that General Counsel is not considered a person that would require the kind of tenure protection that Ms. Wilcox has. I think that's kind of a generally understood position. So they are separate to the extent that there's a staggered position for the members of the board. So I just wanted to make that distinction clear that they're not, you know, that those positions are separate positions. The board has a substantial amount of kind of structural judicial function that the General Counsel does not. So that there is a rationale for the squawking that is accompanying Sister Wilcox and her dismissal versus that of the General Counsel. So I just wanted to make that distinction. Outside of that, 100%, nothing's changed really on the ground for us either.
Right. And you know, the nature of Wilcox's dispute is, you know, constitutional in nature in some regards, statutory in nature in others. There's an old Supreme Court case called Humphrey's Executor that is at issue, and you know, the question there, does member Wilcox's firing violate the requirement that the president only remove heads of independent agencies for reasons specified by Congress? And the tension there is, separation of powers. The executive arguably has the right to determine who is going to be in leadership roles in the executive branch. And so that's where we're seeing the tension here, and ultimately that issue will be decided by the Supreme Court, and will have somewhat of a ripple effect with respect to other agencies. Will the president have and exercise the right to terminate someone from, for example, the Securities Exchange Commission or some other quasi judicial branch of the executive because he doesn't like a decision they made? That could be the potential result here if restraint is not, it doesn't win the day here. So we'll talk more about constitutional challenges in a little while. But I think the next change that is relevant here, well, and before we get there, does anybody have any questions about Glenn Wilcox's discharge and what all that means to the business of the Labor Board?
An explanation would be nice, a small one.
An explanation.
A small explanation. He's talking in generic terms, maybe it'd be helpful.
Well,
Okay,
I guess
go ahead.
Yeah, I guess I can tease this out a little bit. I mean, she was terminated without cause,
Right.
even though she received a letter that had a number of things that could be considered cause. I mean, I wish I could share a copy of the letter. They're not necessarily cause, but
Right.
so it really comes down to whether or not a member of the board with a staggered term can be that performs primarily a judicial function can be terminated without cause. And I'm pretty shocked to see the administration not saying that it was without cause. I guess they're not very confident that they can meet that, or that they want to explore the idea. Again, I'm speculating
Sure.
of whether or not folks can be removed without cause that have these kind of staggered terms, and that don't mesh very well with the presidential cycle. And that also, I think, another area that perhaps, in my opinion, they might want to explore outside of whether or not they can be removed for cause, if they have kind of that staggered term. Also, the issue whether or not folks sitting in the executive branch, arguably performing these, as far as I'm concerned, they call quasi-judicial. I think they're fully judicial to the extent that they're looking at folks that might be considered employers in the administration, or vendors with the administration that might be interested perhaps in what the administration is doing or what the president is doing. For at least the way I'm looking at it, where I stand, it seems like that judicial function needs to be preserved from reach by the executive, but they do sit in the executive branch. They sit in an agency.
They were a threat.
Right. So at the end of the day, I guess we can say is all those things that Lance laid out that the agency cannot do, but given what my experience with the agency has been over the past 2.5 years, it's not that a bunch of cases were getting up there in the first place. I think the firing of the General Counsel will likely have more of a ripple effect, to the extent that her memos were being considered by the regions in determining how to move on a certain matter before then. But there's only a handful of matters that actually go up to the board anyway. And even on the 10J issue, there's been a number of instances where a case has been highlighted, at least over the past 2.5 years. I've been looking at it. A case has been identified as one where the 10-J injunction might be appropriate, and nothing happens. Literally 2 years passed, 2.5 years passed. I must say one last thing, and this is my kind of a pet thing I like to say, that the board was sitting on a number of our charges for 2.5 years. Not so much the board, the regents were. There were no affidavits taken. Sometimes there were affidavits taken, and guess what? We hadn't heard about the next step for a period of time. So what happens? It's getting nowhere near the board at this point, right? It's still, it's not even, a
Sure.
complaint hadn't even been issued.
Sure.
So when that memo went out by Elon and his team saying, hey, what have you done last week? Name 5 things. Man, they sprang into action. I had 4 complaints issued. Well, 2 complaints issued and 2 matters dismissed. I was sitting for 2 years, right? So it might be an unintended effect. I'm not celebrating the fact that A, B, and C is happening, and I certainly wouldn't want, my employer to tell me where to be and what to do. But at the same time, that memo had, I don't know if it was because of the memo or not because of the memo, but we have been seeing that, a number of matters that have been sitting there for a period of time are moving.
So what you're
We have
saying
a-
is
we have a question.
justified in the other, okay.
We have a question out of chat. I would like to have the panel elaborate on the process of petitioning the district court for relief that would typically be directed to the NLRB, but for lack of a quorum. Can someone address that?
Lance, you want to take that?
Sure. I mean, so just to clarify, seeking relief from an unfair labor practice, and going to district court because the board can't vindicate your rights.
I can read it again. Would like to have the panel elaborate on the process of petitioning the district court for relief that would typically be directed to the NLRB, but for lack of quorum.
So, I mean, as it stands right now, there is no process to petition a district court for relief. In fact, a district court, in the absence of 10J jurisdiction, doesn't really have any jurisdiction over unfair labor practices. Those, and to clarify, I'm not suggesting the party would skip the charge filing. I'm asking about appeals to, and what's the rest of it say? See if I can find it.
For relief that would typically be directed to the NLRB. So just asking, can you, what's the process for directing an unfair labor practice charge to the district court?
Yeah, so there really is none. I think that there have been some employer respondents that have sought the district court's assistance when an unfair labor practice has been filed against them, but I don't think that they've seen a whole lot of success in front of the district court, because these courts recognize their jurisdiction is limited in these cases. And, really, that goes to an issue that's kind of percolating at this point in time. And that is, are the rights to be vindicated before the board equivalent to some kind of a right at common law that would entitle you to a jury trial, which would put you in front of a district court normally. And that, that issue is to be resolved. That's another issue that's being fought in the courts right now. And the 7th Amendment right to jury trial is the mechanism that they've been attempting to use to address that issue, but it has not been resolved when it comes to the board at this point in time.
There is a clarification from Jeanette on the question. I'm not suggesting a party would skip the charge filing. I'm asking about appeals that would be sent to the board.
Okay.
So I could kind of jump in a little bit, not necessarily on the same vein as the question, but there are times, as Lance is suggesting, where the employer is landing before the district court, primarily in attempts to enjoin a bargaining order that's been issued by the board or the region, depending on where we are. A number of the employee cases that are kind of percolating in the circuits uh, got there because there was an injunction that they were trying to attempt, and a lot of times they kind of sail through the district court process of pursuing it because the district court denied any kind of like need for any kind of expedited measures to take place. So a lot of times they kind of sailed through that process, ended up in circuit court, and from my understanding, most of those cases, if they're of that kind of a posture, are going to be sent back are either going to be dismissed, or they're going to be sent back to the district court to review the issue of whether or not there should be a emergent enjoining, or there should be a eventual enjoining of the behavior. Well, not the behavior, but the bargaining order, or any other board-related. So this doesn't quite answer your question, but I'm trying to kind of stretch it to the extent where I've seen matters end up before the district court, and most of them appear to be because the employer is trying to prevent the board from enforcing a particular determination. Oh, there was no unfair labor practice on part of the union. There's no challenge on part of the employer. We need to go ahead and move to bargaining. Because the union is the bargaining agent. So that's I don't know if that captures what you're asking necessarily, but the relief is typically provided, I guess, by the circuit courts in terms of direct appeal, and I think Lance can correct me on that in terms of cases moving that have been resolved by the labor board. There's typically the challenges appear on the circuit court, either vis-a-vis the employer trying to enjoin the board from pursuing enforcement, district and then circuit, or the board having made a determination that is thought to be appealable to the circuit court.
Eric is asking.
Generally, go ahead, Vicky, I'm sorry.
Eric is asking another question. I'm sorry to jump in. Does the acting general counsel have authority to seek 10J?
In the absence of this forum issue, he would be able to go to the board and get approval to seek 10J, and then go and seek 10J. But it's up to the board to give that consent, and that's what's lacking here. Mr. Cowan, the interim GC, otherwise would have that authority, subject to the board's approval.
Thank you.
Okay. So speaking of the interim GC, Bill Cowan was put in place as the interim GC. I guess it was about 2 weeks into the administration. Certainly had a mandate to from my perspective, kind of bring things back a little bit more to the middle. And that involved, rolling back scores of general counsel memos that were issued by Jennifer Abruzzo. We have an appendix at the end of this slide deck that lists most, if not all, of the GC memos that Cowan has rolled back and has determined that they are no longer applicable. And so, I mean, that ranged from, things like, should amateur athletes at a college be considered employees under the act, kind of a discrete issue most of us wouldn't be involved in on a daily basis, but certainly a head scratcher for some. Whether or not an employer's use of AI or other technology to monitor employees impinges on employees' rights under the act. That was another thing that was a memo involved and that was rolled back. And then, aside from the memos, we've seen the general counsel withdraw positions on certain issues in front of the Court of Appeals. withdraw exceptions that have been, brought by the General Counsel's office in an appeal to the board. So in an exception situation, they've withdrawn those because it's inconsistent with the policies of the Trump General Counsel's office. And then also, pretty overt statements that Cowan, as interim general counsel, is not looking to change the law in any unfair labor practice cases. And so, for example, on that one, I'm working on a case in which we identified an issue that was kind of shining through on a complaint filed against our client. And we went to the regional attorney who was going to prosecute the case and said, look, this is really, you're seeking to change the law on this issue. And you need to get permission from the General Counsel's Office of Advice in order to bring this allegation, and they withdrew it. So, I think everybody understands that at this point that's the way that Cowan sees it. Now, whether or not that's going to be the way Crystal Carey, who's the nominated general counsel, whether she sees it that way, we'll have to see. The Senate has to approve her, and we'll see that unfold in the coming months. Omer, any other things I might have missed with respect to Bill Cowan?
From my understanding, he's a establishment guy. He's been around the board for a period of time. So I can't imagine there being a huge sea change outside of what we probably saw, outside of the rescinding the memos, as you stated, right? I guess I can add that there was a sense, I think, within our community that there would be more CB cases that would be pursued more vigorously since Acting General Counsel Cowan has entered the scene. I don't know if that is the case, but I do want to kick around the idea of what a lack of quorum up there means, given as far as that's concerned. And I'm going to throw that at you, Lance, to see if you got some thoughts on it.
I'm not sure I understand your question.
Whether or not the acting general counsel is likely to pursue more vigorously any CB cases that may pop in at the regions. I wanted to get your thoughts on that.
I mean, it's rare that employer side lawyers get too involved in the unfair labor practices against a union unless the employer is filing it, and generally that doesn't happen too often. So I don't really know where that might unfold in this current administration. But I would say, when notwithstanding the past position generally that Republican administrations have taken, this is more of a populist administration, and there's a groundswell of blue collar employees that are supportive of President Trump. So he may be more supportive of employees bringing those kinds of claims, not because he holds a position one way or the other against or for a union, but because he wants to support the rights of blue collar workers. We'll just have to see on that. Kind of the next major topic that I wanted to raise was
Lance, excuse me, just one thing. Something popped up before we move on from this issue. I got an interesting text from a friend of mine about this issue of 10J and the authority to seek it. which is that there has been at least one that has been authorized, and he's trying to pull it up. I don't know I don't know any details, but I believe that there has been at least one instance where a 10J has been pursued in the lack of a quorum with only one board member in place, but I gotta pull it up, and so I just wanted to share that, and that's all.
I believe that there are some regs that have been put out previously that attempted to address non-quorum situations. But from my understanding, that the board does not have the authority to seek a 10J. And maybe I don't know. Maybe it was brought at a time when Wilcox was back. I don't know. But I'll happily look at that and comment on that later on. But when it comes to constitutional challenges, and a lot of this started well before President Trump was in office, but it's kind of like part of an ongoing onslaught somewhat against the labor board. And so the first challenge that's notable here is whether or not ALJs at the labor board are unconstitutionally insulated from discharge. And that seems to be developing into a controversial issue because the only case so far that has found that insulation to be unconstitutional is the Jarksy decision out of the Fifth Circuit. Any other court that has considered that issue so far has reached a different conclusion. And Jarksy was an SEC case, so it didn't even involve the labor board, but the SEC does have administrative law judges like the board. And so that's one that we're just going to have to see unfold. We talked about the Wilcox case and Humphrey's executor and whether or not she was improperly removed and whether or not the board's, the statute governing the grounds for removal of a board member is constitutional from a separation of powers perspective. That remains to be seen. And then I also mentioned earlier the Seventh Amendment right to a jury trial, also a constitutional issue. Are these unfair labor practices, any of them, of the nature that you might see an equivalent right being sought at common law in England years ago? It's a kind of a cryptic question, but that's what the courts are looking at right now. Omer, are you aware of any other kind of categories? Those are the ones that I kind of key in on.
I wouldn't speak to any other category, but I will say that in terms of the issue relating to both Wilcox's removal and the constitutionality of the structure of the board, there has been some recent case law coming out of the circuit courts that appears to point, and also, separately considering issues relating to board decisions that they're reviewing, that they, and I can pull up a couple of decisions later on that just got, I think one was out of the Fifth Circuit, and the other one was out of the 10th Circuit, that the function of the board is a judicial function. Similarly, the function of the ALJ is also a judicial function. So how we can Cheshire Cat our approach into how executive, whether or not the fact that it sits in the, in an executive appointed body or congressionally approved, whether or not that even matters, where a lot of the circuit courts are deciding, hey, we're looking at the function. We're looking at how it is that, they're looking at the separation of powers in terms of separation of function, as opposed to where it is that the person sits as well. And I see some case law developing to that direction, and I'm not surprised about it, because that does appear to be a very establishment-oriented position. So notwithstanding the bells and whistles I'm hearing from the other side on, hey, this is an immigration judge is an executive officer. what could possibly happen if we decide to take the approach that that immigration judge it is subject to some kind of influence by the executive, or is subject, or their decision is somehow less valid because they happen to be sitting in an executive agency, for lack of a better word. So I understand the recent development on at least the SEC, but to the extent that we have these bread and butter issues being decided across agencies in terms of without jury trials, but with a judge that thinks of themselves as a judge, I think I think that the establishment, again, I'm reading into the tea leaves based on just a few circuit court decisions. I think that the establishment will win on this one.
One other case worth mentioning that's somewhat constitutional in nature is the Loper-Bright decision, which once again, it's not something that percolated out of the Trump administration, but certainly rings out as kind of consistent with the administration's desire to limit administrative agencies. And in that case, the Supreme Court rejected what's been referred to as Chevron deference, in which courts were to defer to the labor board if it was making a reasonable interpretation of the act when it came to statutory interpretation of the National Labor Relations Act. So that is why we have seen over the years these flip-flops on issues. For example, do Weingarten rights apply to employees at a non-union job site, or do they just apply to union job sites? We've seen the labor board flip-flop on that a number of times over the last 20 years. Both of those positions are arguably a reasonable interpretation of the act. But that really doesn't do employers and unions and employees much of a service from my perspective, because we're all entitled to some certainty in the law. And if the law is jumping around, depending on who's in the White House, that really doesn't help us much. So, the Supreme Court determined that, notwithstanding 20 years ago or so, they implemented this Chevron deference, that they weren't going to do that anymore, and determined that when it comes to statutory interpretation, courts are not required to defer to the board. When it comes to applying law to fact, we can expect that there will be some deference to the board. When it comes to findings of fact and credibility determinations by an ALJ or by the board, courts will defer to the board. And I'll say one thing on that, because I've litigated enough cases in front of the labor board that, it's from the employer's bar perspective, it's a bit of a setup, because an ALJ can drive a truck through his credibility determinations, and then there's no way to really attack that from there. So, I find that to be problematic. Certainly, there's got to be a better standard than just deferring to ALJ credibility rather than de novo or some other form of review that would give a circuit court greater authority to look at those things. So a lot of rubber still to hit the road on Loper-Bright and the breadth of the lack of deference that's going to be given to the board. Omer, I'd love to hear your thoughts on Loper-Bright. It's a controversial case, obviously, but certainly the union has another view of this, I'm sure.
I'm not sure if the union has a different view on it. My view is that well, I think the union's view is to the extent that some of the decisions that were made under the guidance memos that Jennifer Abruzzo had issued, and I'm kind of avoiding the question, to the extent that those decisions can stand as long as possible. So if you guys don't have a full quorum, guess what? If the position is they can't make any decisions, the status quo is what it is. I'm not necessarily talking about the guidance memos generally, but there's a number of cases that were decided with those guidance memos in mind, with the board exercising kind of both what could be considered board law and also what could be considered kind of a interpretation of the law, whatever the applicable law is at that point, you know. And I think that what I heard personally in a lot of the oral arguments that are taking place at the circuit courts relating to Loper Bright and other cases, kind of centers around the idea of board law versus the law, whatever that law is, federal law, labor law. And I've heard it for the first time, this argument pop up, and I don't know which way it's gonna land, whether there is a difference or not, whether or not the Fifth Circuit grilling the union's representative on whether or not, on why they should not talk about board law, but talk about the law. Why should, if not, what does the statute say? Whether those kinds of questions are gonna be looked at the same way at the Supreme Court level. My suspicion is that it's a Fifth Circuit blip, but maybe I'm wrong.
Okay, I'm not gonna spend any time on legislative other than say, look at the deck, and Josh Hawley has, a statute that he's proposing that we should be aware of. I don't know if it's gonna get legs or not, but certainly would impact, first contracts, penalties for unfair labor practices, things like that. And then we
Lance,
have
can I interject briefly on that issue, just real quick, on the issue of
Sure.
the statute? I'm interested in it to the extent that, again, this is a way of, they say, oh, we want to reduce Roe versus Wade to statute. Well, yeah, this is the same thing, to the extent that the labor movement feels like there is a lack of it's too variable across the regimes what's happening to labor law, that they do feel like it's more efficient for employers and employees and unions to find something about labor law that is, generally accepted as the law. So I think that is what's informing a lot of this legislative action that's taking place, and what it's worth, it is generally bipartisan as far as I see it. So I just wanted to interject on that basis.
Sure. And I think it's my turn to turn things over to you, because you were going to cover protected concerted activity and I think a couple other issues, that are pending right now.
Can I cover one thing? The deck that has been mentioned is going to be posted on the members-only website, so it'll be available in several days. But I just want you to know that it won't be generally sent out to all participants, but only to members. I had to have one question that maybe Homer or Walter can deal with. Is there any kind of impact on municipal unions, like the Houston Police, the firefighters, those types of municipal unions from the Trump administration?
I think that's a Walter question.
Yeah, no, I mean, I think it has the same impact on them in terms of the regulations that cover them and any issues they might have with those. I will tell you that there is a parallel issue going on among federal sector employees, though, and that is because of similar issues with the FLRA, where those things like unfair labor practices or a disagreement on how on how an administration ruling was handled would go before the FLRA, and the fear among unions and in some cases organizations that those won't be heard in a timely manner. And so what parties are doing is skipping that process and going directly to court. We saw that in the most recent executive order that the president dusted off, I guess I'll say. It was a 12171, which originally came into play in 79 under President Carter, where it gave the executive branch the right to peel certain parties back from the Federal Labor Management Relations Program. And President Carter did that originally, but so they're allowed to peel agencies back based on involvement in national intelligence, counterintelligence, or national security functions. And Carter did that, and he pulled out the DEA, the U.S. Marshal Service, and then maybe went a little bit broader and pulled out portions of the Department of Energy. When President Trump decided to take that on in March, he took an interesting approach of not crafting a new executive order, but instead pulling that old executive order out, which wasn't currently in dispute, and adding a whole bunch of other agencies to it, including as broadly as the Veterans Administration, VA, and arguing that they're part of intelligence, counterintelligence, and national security functions. And so what it resulted in was about 700,000 to 800,000 federal employees having their bargaining rights stripped because the OPM issued a guidance to the agencies that said, cancel those collective bargaining agreements. You don't have an obligation to them anymore. And so why is that meaningful? Some of those same agencies who had covered employees are undergoing the same reduction in force as, say, the FMCS. And those unions had a right to bargain over the impact of those reductions. They couldn't bargain over whether or not, in my opinion at least, they couldn't argue over whether or not the reductions could occur, but they could bargain over the impact. And they lost the ability to bargain over the impact because they were stripped of their collective bargaining rights. That's in the court system now. The parties skipped the FLRA, and I think the stated reason that the parties have made in front of the courts is that they didn't feel like it would be timely adjudicated before the FLRA. The courts, the act provides that the courts are the last effort that you do after you go through the FLRA, and so they chose to skip that. And it's largely for the same reasons that we're seeing under what Lance and Omer have talked about.
I actually, you know what? Since I got a chance to think about it, I kind of see a weird intersection, which is, back in the day, I used to do discrimination cases coming out of a school system, the Atlanta public school system, right? And they typically have a union or multiple unions. And a lot of times in discharge cases, those cases of first impression are heard by a hearing officer. That function I see in a way, if somehow we are able to decide that no matter where it is that a particular judicial officer, hearing officer, whatever you want to call it, ALJ sits, and somehow they need to be, supervised by the body because it happens to be an executive body. Well, guess what? At that point, it's a wild, wild west, because I think hearing officers' functions also could come into, that's typically an attorney, typically may or may not have worked in some capacity with the school or with the municipality, whatever it is. So I do see, I see a danger of there being too much oversight on somebody that's exercising a judicial function. Sky may not be falling, but I kind of see those arguments not being applied to, okay, is this hearing officer a proper person to be looking into it? Whether they should be monitored by the school district to the extent that they are working to some extent in the General Counsel's office or whatever else at some point, or had. So I don't know if that's necessarily addressing your question, but those kinds of, if we can open up the judicial function to, okay, now we need to consider where it stands, where it sits, right? I think the sky's in the limit in terms of whose authority you can challenge, supervise, or overturn.
We have about 5 minutes.
Great. I love it.
Finish up.
I can deal with a number of cases. I think, you know, there's only 3 cases really that have been decided in March, by the board. So one relates to, this is, not quite in the order that it was in. It's called Dumbo 301 LLC, doing business as Magic Tavern. This was decided in March, that little brief period of time that Sister Wilcox was back at the helm, well, not necessarily at the helm, but back with the board. And then it was the easiest thing to do because it was a default judgment that was rendered by the ALJ, and the board found that, I mean, it was easy because the respondent really didn't participate in the process. But they're, you know, what was interesting about it is that they applied the kind of idea of the full panoply of remedies that are available to the UOP cases, to the extent that kind of tracks what one of the rescinded memos deals with, that those full panoply of cases, instead of just, you know, reinstatement back pay need to be available. And this is interesting to the extent that there's a board decision on, you know, applying that. And it would be interesting to see whether the board is going to continue to issue these kinds of, you know, decisions, default judgment or otherwise, given the fact that that memo has been rescinded. Then we have another matter. It's in fact 2 board cases decided March 28, 2025. It relates to Pacific Bell Telephone Company, doing business as AT&T, the CWA, Communication Workers of America. And there, in terms of whether or not 6 months was too long for a request for information to be responded to by the employer, the board declined to apply the CBA, the collective bargaining agreement between the parties, and it still determined, okay, well, we're going to determine on our own, right? Something that I think everybody believes they have the authority to look into, right? We're going to determine based on looking at kind of a multifactorial approach that existing board law allows to whether or not the 6-month delay and all the excuses given by the employer in terms of the delay were, you know, whether that was unreasonable, whether it was excusable, et cetera. There is an ALJ decision in that slide deck that was issued in the absence of a quorum. It was a dispositive motion. There's a regulation that allows for the chief ALJ to look into the dispositive motions, motion to dismiss, summary judgment, etc. 29 CFR 102.179 authorizes them to do that. I found that interesting, so I just put that in there, even though that's not technically a board decision. And then in terms of, by the way, I have a number of circuit cases in the deck as well, but we don't have enough time to go over. I will go over this last decision that came out also March 21st, 2025. It's a Starbucks decision. And the case involved whether or not a matter that was severed out of the case relating to remedies, whether or not a bargaining order could still be enforced if a little piece of the remedy was taken out, whether or not, and it was decided that it could be pursued. All the other remedies could be pursued. The other issue with that is that the General Counsel, Cohen, at the time was urging the board to reconsider and overturn an existing case involving employers not being required to tell the union when they were engaging in a discretionary discipline of an individual employee before reaching an agreement, a bargain agreement with the union. So the fact pattern is there's an employer, it represents workers, but they haven't reached an agreement. Somebody's being disciplined. What do we do in that instance? Is the employer required to notify the certified union or bargain with them over whether or not that person needs to be disciplined? And the existing case saying that they're not required to do so still stands. And here the board appears to, at least to some degree, be, the kind of balanced, so we've run out of time, so that's great.
Do you have any final comments?
My final comments, thank you for inviting me. I wish we had more time, and it was good to kick this matter around with Walter and Lance, both on and off this whole venue.
Walter, any final comments?
Just thanks for including me on the panel. I appreciate the participation from the group here as well as the group online. And thank you to Lance and to you, Omer, for the heavy lifting that you did on this.
And Lance, any comments?
No, it's been great. We're in the Wild West right now, so I just hope everybody stays safe.
Good characterization.
Let me make a couple of final comments, and I do apologize for the background noise. We'll have to figure out something to do that. This owl that we're using for the first time is sensitive. It's picking up more than we thought. I do want to thank Lance and Omer and Walter. I thought it was a really outstanding panel and really appropriate and hit some things that we need to know about. Be sure to put in chat your Texas Attorney and ZLE information, your name, Texas Bar, and for SHRM, put in SHRM Research credits and your name, email address, and cell phone. The charts and the video of this will be available on our website in a few days, probably first part of next week. And that would be accessed by Houston LERA members. And finally, on behalf of the Houston LERA Board, we just want to thank you for taking the time out of your day to attend this program, and we hope to see you again at future LERA events. Thank you very much and have a great afternoon.
Thank you, Mickey.
Bye, everyone.
Thank you.
Jack, I'll get yours if you'll give it to me.
Good job, everyone.
We'll get it
Very
to
nice.
you.
Yeah, very good. Can I make one comment, though? This was so much information, and it was so good, but it was so detailed. It's more than a 1 hour. And once we have the opportunity to look at the slides and kind of fill in some of the gaps for some of us, I would like to see this program again coming up soon, because I think there's a lot more that needs for follow-up, and I think it would be very helpful for people you've given us a framework, we'll look at the structure inside these slides, and then have an opportunity to hear it updated sooner than later, though. I don't want to wait for another year. There probably won't be another year with this regime. So we need to do it sooner than later, and I think it's very important for the membership. And a lot of the legalese, half the group are not lawyers. Or if they are lawyers, they're maybe not practicing in this area, so some of the acronyms
Let me
might be
get out of
helpful.
the meeting here.
Oh, I'm
Emily,
sorry, I thought we
will
did.
talk to you later.
Well, they should
And
hear it too.
Thanks, everyone.
In my
Thanks,
word,
Mickey.
never volunteer.